Bankruptcy Mediations, a conversation with Sylvia Mayer. That is our topic for today. Welcome to the Lawyers and Mediators International Show and Podcast by instantmediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube, the Instant Mediations app, and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact-dependent. Hey everyone, Mac Pierre-Louis here, attorney mediator and arbitrator working throughout Florida and Texas.
And Natalia Łowska-Czajka, advocate, mediator, and arbitrator from Warsaw, Poland, with our special guest today, Sylvia Mayer, who really gave us this huge pleasure to appear with us today. Sylvia is based in Houston, and she does the whole variety of commercial, civil, and bankruptcy mediation. And she's also an attorney. Sylvia, can you please tell us some more about you and your practice?
Well, thank you. Thank you all for having me with you today. I really appreciate the opportunity. So I am, as was said, I am an attorney, an arbitrator, and a mediator. I've been practicing law for almost 30 years, doing business bankruptcies and commercial litigation. And in 2014, I started really diving in deep into ADR, doing mediation and arbitration. I do all kinds of mediations, bankruptcy, commercial, civil, healthcare, etc. And I also do arbitrations as well. I am physically located in Houston, Texas, but I arbitrate and mediate matters all around the country.
And having said that, everybody who is interested in learning more about Sylvia is absolutely welcome and invited to visit her website, which is smayerlaw.com. smayerlaw.com.
Thank you. And for those who might be listening, it's SMAYER law.com. All right. So, Sylvia, thank you so much for agreeing to talk to us about this very important topic, and that is bankruptcy mediations. It's something that Natalia and I are a little familiar with. We've both have handled personal bankruptcies in the past with other clients, but you specialize working with businesses and not just with bankruptcy, but also commercial disputes. And so since this channel has turned into topics that focus on conflicts, managing conflicts, whether it's interfamily, international, or interbusiness, can you tell us a little bit more in this episode about bankruptcy law, but start off with just giving listeners and viewers a little bit of a bankruptcy 101, all right? Just kind of lay the foundation for us on what is bankruptcy mediation generally and bankruptcy specifically.
Absolutely. Happy to do that. I always say that the first step in any specific industry or practice area is learning the vocabulary. And so let me teach you a little vocabulary here. So the first thing to understand in bankruptcy is, the first thing to understand in bankruptcy is that it is all about conflict resolution, and consensual resolution is encouraged across all lines. So in contrast to other areas in bankruptcy, we're all about negotiating and trying to find resolution if we can. There are several different chapters of the Bankruptcy Code, which is a federal law. And depending on which chapter of the Bankruptcy Code you're in, that determines the type of case. So for consumer bankruptcies, those tend to be either a Chapter 7 bankruptcy or a Chapter 13 bankruptcy. Then for commercial bankruptcies, businesses, those tend to be either a Chapter 11 bankruptcy or sometimes a Chapter 7. Occasionally, you'll have individuals who file Chapter 11 as well. And so let me explain the difference between that. A 7 is a liquidation, whether it's for a person or a business. A 13, which is only for individuals or consumers, is called the wage earner chapter. And an 11 is for reorganization. And a lot of times people think reorganization means that you're going to figure out some things about the debt and how the company works, and then the company is going to come out the other side and continue on. but that's not always the case. You can actually have a liquidating reorganization. So there's a lot of complexity to bankruptcy. There's another chapter, chapter 9, which deals with municipalities like cities and municipal utility districts, but we're not going to really spend a lot of time on that one today. One other important term that you need to know is, in contrast to litigation outside of bankruptcy, where you're typically talking about plaintiff versus defendant, or in arbitration, claimant versus respondent, in bankruptcy, the person or entity that filed bankruptcy is called a debtor. And everyone who is saying they're owed money is called a creditor. And so most disputes are disputes between the debtor and the creditor or creditors. And occasionally there's disputes between creditors that affect the debtor, but the fight is actually between the creditors.
Very happy to hear all that. And that really makes us and places us in certain positions. And since we're already talking about the basics of such mediation, can you please tell us who the parties usually would be to such mediation? How would it start and finish? And what sort of claims can be seen in such mediations?
Absolutely. So you can have two-party disputes like you have in all other sort of normal, what we call normal mediations, where you would have you'd have debtor versus creditor, or creditor versus debtor. And that's very common. You often will see that, for example, in claims litigation. So what will happen in a bankruptcy is something called an automatic stay goes into effect when the debtor files bankruptcy, and people can't ask to be paid what they were owed before the bankruptcy was filed. Instead, there's a process where the debtor says what they think they owe people, and then people get to come back and say, no, I disagree with that. And then if there's a disagreement, there has to be something to solve that. And that something can be a negotiation without a mediator, or it can be a negotiation through a mediator, or it can be litigation. And so that's a very common area where you will see bankruptcy mediation. Is a creditor says you owe me more, debtor says no, I don't. So then debtor files what's called a claim objection in the bankruptcy. And so that looks very similar to plaintiff versus defendant type mediation, except that what the defendant will ultimately recover if they agree to a claim amount, or if they ultimately get a judge to enter an order in their favor, is not 100 cents on the dollar, but something we call bankruptcy dollars, meaning whatever the percentage recovery is in that case for that type of creditor. In contrast to those types of disputes, there's lots of other issues that come up in a bankruptcy case that involve multi-party mediations. And I have had several mediations where I have had 7, 10, 20, 30 different parties. And it's very complicated because you not only have a lot of parties, but you have a lot of issues that have to be sorted through. And if the debtor agrees to give something to this party, that takes something from that party, and you have to find the balance in order to reach a resolution. And so that's one of the complexities sometimes in a bankruptcy mediation.
Yeah,
there are other two-party disputes, and I can talk about those too if you'd like.
Yeah, no, sounds fascinating about the multi-party disputes, because I can imagine that if you have a certain number of creditors and one debtor, I can imagine that you could start creating fights in between the creditors, right? And how do you typically handle such a complicated setup?
So there's a lot of issues that can come up between the creditors. So first of all, you should understand that in a bankruptcy, you have a waterfall, which means the money first goes to pay secured creditors, then it goes to pay unsecured creditors, then it goes to pay equity. So people who are stockholders, and everybody should understand this, when you buy stock, you're last in line in the event of a bankruptcy and only get anything if something's left. But sometimes there'll be a fight between the unsecured creditors and the secure creditors, because the unsecured creditors say, whoa, secure creditor, you're not really secured. We want to bring some of what you think you're owed to come sit with us in the unsecured bucket. Or you'll have unsecured creditors who are fighting because they may have some kind of intercreditor agreement that changes the priorities between the creditors, or there could be a variety of other issues. Somebody may be alleging another party committed fraud or breached some duty, or keep going on all the different things that people can say in a fight where you have a pie and the debt is this much, but you only have half a pie left. And so they're trying to fight to get as much pie as they possibly can.
This is why this is so fascinating, because Natalia and I, for what we do, we would never have had the opportunity to kind of get this behind the scenes view, except from people like you. So appreciate that. Wanted to talk to you about types of disputes. What kind of types of mediation disputes are out there, or bankruptcy disputes are out there?
So I mentioned earlier that you can have claims litigation, which is just the most straightforward. Creditor says you owe me X, debtor says no, I only owe you Y, and you're fighting over that, and that's what you're mediating. You can also have different issues that come up in the bankruptcy case in terms of how the debtor is going to wrap up their bankruptcy case. So in a Chapter 11 case, the debtor needs to have a plan, whether it's a liquidating plan or a plan of reorganization. They need a plan. And the plan is basically a contract that says, this is how I'm going to divide up whatever value I have to pay my creditors. And so a lot of times you mediate that plan. And that frequently can't be done in a day. A lot of times it's very complicated, and you have to work through these intercreditor issues. And sometimes there may be additional information that needs to be shared, or there may be a gating issue, a legal issue that they can't settle, and the judge needs to decide that issue before you can then build a path to resolution. The other thing that's interesting in bankruptcy is you get a lot of shifting alliances. Even if everyone doesn't agree, the judge can approve a plan over some creditor's objection as long as certain requirements are met. So you could have a mediation where there's an outlier. There's somebody who keeps saying, no, 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 but everybody else has agreed. It is possible that the parties would then move forward with that settlement that was negotiated in mediation, even without one of the participants' support. So it's a very interesting thing. And I will also say you do sometimes have these same dynamics in out-of-court restructurings. Before there's been a bankruptcy filing, it may be that the parties are trying to negotiate a way to resolve all of the debt without filing bankruptcy. And I've mediated some of those as well, out-of-court restructuring negotiations. So it doesn't always occur within a formal bankruptcy, but it occurs in the context of a potential bankruptcy or an actual bankruptcy. Another area where it's very common to see two-party disputes are avoidance actions. And that's a special thing that comes up in the bankruptcy code. Most state laws have fraudulent transfer actions. The bankruptcy code also has a fraudulent transfer section, and it adopts applicable state law fraudulent transfer claims. But it adds one more thing, which is a thing called a preference. And so it is very common, particularly in large corporate bankruptcies, it is very common that the debtor will file hundreds of preference actions. And what a preference action is anyone who received a payment in the 90 days before the bankruptcy filing, the debtor will file a preference claim against them if they think that creditor was treated preferentially in some way, so that the underlying policy argument is to equalize what creditors get. So if, for example, one creditor was owed money and made a whole lot of noise, and so they got paid, but all the other creditors didn't make enough noise and didn't get paid, then the underlying policy argument for preference actions is that one guy who was the squeaky wheel shouldn't be treated preferentially. If everyone else is getting 50 cents on the dollar, they shouldn't get 100 cents on the dollar. And so there's lawsuits about that. The bankruptcy code also has various defenses to those types of claims. And that's really the guts of what you're mediating is here's the claim for the preference, here's the defenses, how do those fit together, what's your likelihood of success, cost of litigation. So many of the things that you would consider in that mediation are similar to what you would see outside of bankruptcy, but it's a claim that is unique to a bankruptcy case. And I will also say in the disputes that we think of as two-party disputes in bankruptcy, it is possible there will be an additional party, because in some cases there is what's called an unsecured creditors committee, which is a body that is appointed by the Department of Justice. And they are there to protect all unsecured creditors, not each individual unsecured creditor, but just generically all unsecured creditors. And sometimes they have a seat at the table in the mediation as well. And so it's one of the things that creates interesting dynamics for bankruptcy mediations.
And after hearing all this, how interesting it can get, how many different aspects of it can be, how many parties can participate, how many contentious issues you can have. Can you please tell us what is actually the use of mediation in bankruptcy? Meaning, at which stage of the proceedings, who would initiate it, who would encourage it, and whether it differs anyhow in the dynamics of this absolutely complex process?
So the answer is it varies. The short answer is it varies all across the board. So first of all, there are some areas in the United States where the courts have embraced bankruptcy mediation, and it is ingrained in their system and has been for decades. So there are some jurisdictions where when avoidance actions are filed, the local rules say you're going to mediation. There are other jurisdictions that don't have that. You then have the question of timing and when you go to mediation. And ironically, I literally just wrote a paper on this issue. Typically in avoidance actions, particularly for preference actions, since we were just talking about that, those cases often go to mediation before there's any discovery, because both parties really have all the information, or most of the information they need. It's invoices, payments, checks, and they can share that informally, and they can typically go to mediation pretty quickly and don't have to spend a lot of money on discovery before they try to resolve it. They may still, if they can't resolve it, they may go on, and it may be premature, and you could mediate again later. In contrast, I talked earlier about planned mediation, when you're trying to figure out how the company is going to come out of bankruptcy. And while that can happen early in the case, it typically happens later in the case. Once the debtor has stabilized their business, they have sorted out, there's usually some basic issues they've sorted out in the case. There may be a consensus around certain things, and they come to mediation. I have had parties come to planned mediation, and it becomes clear in the process that it's premature, that there's just too many variables to be able to find a resolution. And then we can either pick off a couple of discrete issues to work on and just solve those for now, table the rest for later, or we can establish, say, an informal information exchange to try and bridge that gap. Or we can have some preliminary sessions and then say, let's take a break and let the judge rule on something, and then come back together. There's lots of ways to handle that. The claims part, which is sort of the other big bucket where you see bankruptcy mediations, that can happen at any time. And then I'd say one thing I haven't really talked about is there are sometimes operational issues in a bankruptcy case that need to be mediated. The use of cash is one that comes up frequently. And so sometimes that'll happen early in the case. There's a fight over whether the debtor can use any or all of their cash, which obviously they need in order to be able to, say, pay their employees, buy more goods, whatever their thing is, that how they operate their business. And so sometimes those types of issues will go to mediation.
Gotcha. So Natalia and I are very used to this model where we'll do 1 hour or 2 hour or 4 or 8 hour mediation. But in your world, when you're dealing with businesses, what what should we expect in a bankruptcy mediation? Are we talking about weeks? I mean, how long do they last? Can you give us a little bit of context?
Sure. So in the context of, say, preference mediations, is very common to see those be done in 3-hour time blocks.
Okay.
So you might stack, if you have a case where there's hundreds of preference actions that are filed, it's possible that you'd stack those. And so a given mediator or the debtor might be mediating 3 or 4 cases in a given day because they're stacking them up. There's not a lot of other issues that happen in bankruptcy that can be done on that timeline. And that's only because in preference actions, you don't have, typically people come to the mediation already having all the information they need, and there's not a lot more to share. I will say in consumer cases, and while I never really practiced consumer bankruptcy, I have mediated consumer bankruptcy issues. I find that most of those issues do require a day because there's a lot of emotion around those issues. And plan type or cash collateral type, the sort of bigger multi-party things, it is very common that those would be a multi-day process. Now, I will say I forget if there were 7 or 8 parties. I think there were a total of 40 people in it. I did a Zoom mediation, I don't know, maybe 2 years ago, year and a half ago, I've lost track of time, that was an out-of-court restructuring. And I think we were on Zoom for 14, 16 hours, and we got it done in one day, but it was one very long day. But most of the time, when you have that level of complexity and that number of parties, it's very common that you need to spread it out over more than one day.
Gotcha. So could you talk a little bit about how COVID has impacted all of this? Because we talk about the Zoom revolution, quite a bit now. But beforehand, I mean, I'm surprised you were actually doing Zoom mediations a couple of years back, right? But how has COVID-19 and the Zoom boom affected bankruptcy mediations for the whole country?
So I have mediated cases from all around the country since I started mediating. And so that has not really changed, that a mediator sitting in Houston could mediate a dispute pending in, say, Delaware bankruptcy court. What has changed is frequently people would pick their mediator based on where one of the parties is physically located. And so maybe a Delaware case would pick me in Houston because the creditor who's been sued is in Houston. And so that's where they're coming. And that's just a made up fact pattern. But so bankruptcy mediation is sort of a national platform. But the Zoom boom has made that much more accessible to everyone. And it has changed the dynamic because in preference mediations in the past, cost was really a big issue. Flying people into the different places for the mediations was a major factor. You have the debtor on the one hand who's trying to save money to pay their creditors, and you have the creditor on the other hand who's saying, wait, you want me to give you money back? So they don't want to pay for the cost of mediation. So I think Zoom is very likely to continue to be an important part, particularly of preference action mediations. But I had a mediation the end of last year that was a multi-party dispute spread over several days. And we had people who were decision makers who probably would never have physically attended a mediation because they were very senior people in very big organizations, international organizations. But to join a Zoom call, it was easy because we would set aside a day, and I use a system where I text and I knock on the door virtually by text before joining a room. And so they were able to say, give us 5 minutes so we can go get, super senior guy and get super senior guy on the line. And so it really has changed a lot about how we mediate. And I think that's true outside of bankruptcy, but certainly in the context of bankruptcy mediation.
Okay, and Sylvia, if somebody does have a bankruptcy issue and they need to get in contact with you, I know you provided your email on the screen, smayer@smayerlaw.com. But how else can people get in contact with you?
They can certainly go to my website. They can email me, and I am also on LinkedIn. I think if you just search for Sylvia Mayer bankruptcy, you'll probably find me. But those are the best ways to find me.
And now it will be time to wrap up our absolutely fascinating conversation. Thanks to Sylvia. Thanks for bringing all these issues to us. Me being from a different continent, from Europe, listening to that, I, of course, was in my head comparing that to what we have here in Europe. So, first of all, we do have cross-border insolvencies procedures. Then, all the complexity that comes with differences in languages or where it started, who takes over in case of a multinational entity. All of that is absolutely fascinating. But one thing that, for example, is specific for Poland, just to say about that would make the mediation more difficult, is that we do have categories of privileged debts, meaning privileged creditors, which is state treasury for taxes, which is social security for social security contributions. We do also have a privilege for example, on the child support or alimony. So these are like preferential debts that also have their own place that needs to be satisfied first if you have this waterfall of satisfaction. But I do believe we have not covered everything that is actually relevant to bankruptcy mediation. I do believe that we have still some more to say about particular varieties in it, but also confidentiality and the court role. So the role of the court and court approvals in the mediation. I do believe there will be an opportunity for us, if Sylvia agrees, to cover that as well. But saying that and wanting our listeners and viewers to follow more about Sylvia and on the topic of bankruptcy, which we'll definitely be covering, we want everybody to just feel invited to go to our Lawyers and Mediators International YouTube channel or listen to our podcast to learn some more. And for now, it will be all from us, and hope to see you soon. Thank you so much, Sylvia. Signing off. Bye-bye.
Bye-bye.